Attorney conduct. Hey, as we all know, attorneys, in terms of what they can and cannot do, are regulated by the state bar in which they are licensed. But what can attorneys do and what can't they do? Well, that takes us to this week's case. It involves a real man, a fellow by the name of Bill Lax. 76 years old. 76 years old, had been practicing law for 46 years. He was representing a client, a female. He was doing a good job on her behalf. She was very pleased with what he was doing. And then one day, when she was talking with him, he said to her, "You know, I've always found you very sexually attractive. I'll tell you what, I will pay you $100 for each and every sexual activity you engage in with me. Call me anytime, day or night." Well, whoa. She was a little taken back by this, and she really didn't know what to do initially by virtue of the fact that she was pleased with his service. He'd been doing a good job for her, but she was really offended by this overt sexual advance that he made towards her. She reflected on it a little bit, and then she went to the State Bar Disciplinary Committee and said, "You know, this is what happened, and I am not at all happy." Well, the State Bar approached him and said, "Hey, what's the story here, Bill? Did this really happen?" Being good, honest, and true, he said, "Yeah, it really did happen." They said, "Bill, you can't do this kind of thing, and we're going to have to take a hard look at this." So it proceeded through the disciplinary committee for the State Bar. State Bar came away and they finally concluded, "You know, you've practiced law for 46 years, and this is the first time we've seen any complaint against you. The complaint is definitely one that bears merit by virtue of the fact you agree that it did take place, and it's also one that compromises you in the practice of law because, Mr. Lax, you cannot serve two separate interests. In this instance, you have a right to vigorously represent your client, and that vigorous representation is going to be compromised by your sexual interest in the client, and therefore you cannot be as impartial and as good in the representation as you might otherwise be. Plus the fact, making a monetary offer for sexual activity, well, frankly, that's contrary to the administration of justice. So, my friend," they said to him, "you are given this remand, and you are told never to do this again, and this is going to be published. So all the world will know about this." But the State Bar did not suspend his license. The State Bar did not disbar him, did not prevent him from practicing law in the future. And the reason the State Bar did not, as they explained, was because he had practiced 46 years without ever any kind of an issue, and because he had fully cooperated in the investigation in this particular complaint. He fully came forward and said, yes, that's what happened. Okay, so what do we learn from this? Well, we learned something very important that we've talked about on these legal video blogs a number of times, and that is attorneys are held to a very high standard of care. You know, if the same thing had happened, if this woman had been going into the same shop year in, year out, getting her car taken care of, maintained, serviced, and one of the mechanics there every once in a while would make some snide comments to her, might have made an overt offer to have sexual activity with her, would agree to pay her $100. Well, she wouldn't have been happy with that. She might have complained to the owner. The owner might have said, well, Jim, Joe, hey, you got to knock it off. Or the owner might have done nothing. The owner might have even fired the guy, but something would have been done by the owner. There wasn't any public committee that was going to investigate this. There wouldn't be any charges brought. Whoever the mechanic was, his livelihood, his license, his ability to practice as an auto mechanic would not in any way be impaired. You know, think about Bill Clinton. When Bill Clinton was president, as many people might remember, he gave a deposition before a federal court. And in the deposition, he was asked a number of questions, and the federal judge found that he essentially was lying, said that his answers were so incredible that she said he was lying. As a result, she imposed a sanction, a fine against him of $90,000 for taking up the court's time and taking up everybody's time and then lying in the deposition. Then the state of Arkansas, where he was licensed to practice law, looked at this and said, you know what, this is some pretty bad news conduct, and we're going to suspend your ability to practice law for 5 years, So while he was sitting as U.S. President, he could not practice law. If he had been a private citizen, he wouldn't have been able to make any money practicing law, even though he'd spent years in school to get that law degree. That is how important discipline in the practice of law is, and how important it is that lawyers tell the truth, how important it is that lawyers basically act according to those ethics that are set forth by each and every state bar. Okay, we bring you this case, as we bring you cases every week, so you understand how the law works. I'm David Alley.